Lawyers, what is your best case that you didn't want to take first? Story 1. I try to avoid family court because it's such a cesspool, but occasionally I'll take order of protection cases because they're close to criminal cases. I took an OP case from a guy who lived out of state, resolved it pretty easily. Then the guy said he needed help with a custody matter. His ex-wife lived in my county, and they were having a custody battle over their 5-year-old daughter. She refused to return the daughter after a visit and stopped coming to family court in his state where the matter was being heard. The judge ordered that he be given full custody immediately. Now he needed to get it enforced in my state. I decided to help him out. Even though he really didn't have much money, I felt bad, so I decided to handle it for a nominal fee. After some research, I learned that I needed to prepare a petition under the Uniform Child Custody and Jurisdiction Enforcement Act, requesting that a judge in my jurisdiction enforce the other state's custody order. That was granted, and I served the petition myself to save the client money. Ended up being nail and mail. We also learned that the mom had pulled all of her children suddenly out of school and hadn't been seen since. She had family out of state and out of the country. We got an expedited date before the judge. When she didn't appear, he issued a warrant for her arrest. I contacted the fugitive squad at my local police department and sent them a copy of the warrant. While this was happening, I found out that about a year before all this, she had filed criminal charges against my client, which he was never informed out, and there was a warrant for his arrest. I got the warrant recalled and let the prosecutor know what was going on and sent her a copy of the wife's warrant, and she agreed to dismiss the charges. It turns out that the wife had a kid with another guy who also had a custody order he was trying to enforce, so he was trying to track her down as well. About 8 months later, she was caught by the police in Texas. My guy flew down and got his daughter back after over a year, and the wife was arrested and charged with kidnapping. I put a lot of work into this case, but it was definitely satisfying when it was all resolved. Story 2. I was a second-year associate and handling my first trial. I represented the plaintiff. The defendant had an expert witness who had testified previously in about 40 similar cases. This expert came out to my client's property and did a completely flawed examination of the issue, and his expert report was equally flawed. For those of you that don't know, expert testimony needs to meet a certain standard, the Dober standard, at least in my state, in order to be admissible. This guy basically took some photos and put a ruler on the ground a few times to make his report seem legit. The partners at my firm told me it wasn't worth trying to file a Dober motion to strike his report/testimony because the case was low value, under $100,000, and those types of motions can be very complex, and didn't want to bill the client for it. I was so angry about this guy being deemed an expert that I came in on a weekend, on my own time, and drafted a 20-page motion to strike his testimony. I didn't bill the client a dime. The defendant didn't file a response to my Dober motion to strike. Instead, they waited until right before the expert was set to testify. He had been sitting in court racking up fees for 2 full days beforehand. The judge had the jury leave the room, put the expert on the stand, and allowed the defendant to do a direct examination of their expert. The defendant's attorney, not taking my motion seriously, had their inexperienced associate, just like me, do the examination. It was incredibly basic and didn't respond to any of the points in my motion. I was in charge of doing his cross-exam. It was my first cross-exam of a witness, ever. I tore the guy, a seasoned expert witness, apart on the stand. I got his entire testimony and report struck. They also had a second expert witness, who was pretty terrible but not quite as terrible. I also did his cross-exam. Realizing that they were in serious trouble without their primary expert, and their second expert at risk of getting struck, the lead counsel for the defendant, a named partner at a well-known firm, did the direct exam for the second expert. I again did the cross. I got the second expert's testimony struck, except for one very, very tiny area. So essentially he was forced to testify with both hands tied behind his back. It was the most gratifying moment of my legal career so far. Story 3. It depends on whether you're asking about my favorite outcome or a technical victory. I'll give you a short story about one which is, I guess, both of those things. I had a client who is learning disabled. Client can read, but doesn't comprehend the words that they're reading. Client was charged with an offense, which would require careful reading of a particular document. Prosecutor didn't believe that client couldn't read for some reason. It was a young person, so I provided their school IEP. Prosecutors still didn't believe me. I met with client to discuss the charges and review documents. We spent many hours together leafing through records. Not only was client not guilty of the offense in the first place, but client was also very obviously unable to understand any of the writing on the docs we were reviewing. Prosecutor still didn't believe client couldn't read for some reason, but I ended up battering him for several hours until he finally dropped the charges. Before I dug into all of this with client, a supervisor told me not to review the documents because it would be a waste of time. I went ahead and did it anyway, even though no defense lawyers should waste time on this, the prosecutor has the burden of proof. The reason I am proud is because another attorney probably would have written client off as a liar, resulting in undue punishment. My persistence got me there. And my argument was sound and technical. So much so that I really upset the prosecutor. Story 4. As a young attorney, I had stated a claim that an insurance company was dragging out a case in bad faith, in hopes that my elderly client would die before they had to pay him. I was requesting that the trial date be given priority due to my client's advanced age. The judge was no spring chicken himself, and seemed skeptical when he asked exactly how old my client was, maybe thinking that he was in his 70s and must merely seem ancient to a baby lawyer like me. When I responded that my client was 92, and the case has already gone on for 5 years, the judge was visibly shocked and immediately granted my motion for priority, shutting down the insurance company's attorney's attempt to respond. They wrote us a check for $1 million the next week. Story 5. I had a pro bono client, a wonderful hard-working Jamaican immigrant, whose roommate intercepted credit card applications, applied for them, and left my client with a mountain of debt she didn't incur. I got the credit card companies to forgive all of it, and didn't charge my client a dime to do it. She was an amazing woman, brought joy to everyone she met. I'm lucky to have met her, and we're lucky to have her in our country. I wish it was that simple. When they tried to collect the debt, I filed a declaratory judgment action against them in my jurisdiction. I sued them, sent them a mountain of discovery, and started the process of setting their people for depositions here, so they would have to hire lawyers and travel. I also had my client file a police report and sign affidavits attesting to the fact that she did not incur the debt. Only after all that, and me telling them I was doing this for free so I could make them spend multiple times the debt in attorney's fees, did they come to their senses. They had to prove that she signed the applications and spent the money. I knew they couldn't, and I called their bluff. Story 6. Back in my public defender days, before regular government work, I handled trials/hearings during the week and prepared appeals on the weekends. I developed blitzkrieg researching and writing skills, which I needed when appointed as guardian ad litem for an elderly woman already adjudged incompetent but diagnosed with throat cancer, in addition to ongoing emphysema likely ending her life within 6 years. The public defender assigned as her attorney was ready to sign off on excision of her larynx, which the doctors deemed the most effective treatment, but which required learning to use a device to replicate speech. As the attorney representing her best interests, I listened carefully to her and found that all her life she avoided medical intervention, so she wanted radiation therapy, which was number 2 on the list of acceptable modes. The judge ruled in favor of surgery, but I was able to get the state's highest court to accept the case on a rush basis. In 3 days, I managed to research and write the appellate paper, laying out the grounds for the woman's choice, which, after oral argument before the 9 justices, resulted in a unanimous decision in the woman's favor, just hours later. The later written decision explaining the court's decision made law for that state, served as guidance for similar cases in other states, and put in place protections for vulnerable patients facing a medical crisis. As for me, I got the rock star treatment for a while, when my identity became known at legal occasions. Everything about the case was unexpected, but you learn to roll with the waves. My career is completed. My public defender days were very much like MASH, the TV program. Lots of intense cases, done with very few resources, like sufficient time. Since a portion of my work included representing patients on a mental ward, it was very fortunate that I lived only 2 blocks from the involved hospital for the usual 8 a.m. hearings, and mental health law was my best subject in law school. When the court decision was published, I am sure my constitutional law professor was surprised, because as a sleep-deprived holder of 2 jobs, I napped during his class, and yet this case depended heavily on that area of law. When you are committed to doing right by your clients, the way forward is very obvious, and so I just did the obvious thing, and this time everything lined up right. I had a key to the law library, so off-hour use was unlimited. My children's father completely took over parenting for those 4 days, and I already was doing my own typing of legal papers. Key to this case was my familiarity with mental health professionals in the community, one of whom took me aside and told me that giving this patient more time on good oxygen would result in increasing mental. Story 7. My most challenging case wasn't factually complicated, but rather, so I had to sue a quadriplegic woman. She had been in an accident, and shortly after her family had abandoned her, and she spent a long time in healthcare, racking up a $3+ million bill. All of this would have been forgotten, except some of her family that never visited, contracted with a rather flamboyant plaintiff's attorney who filed a suit and received a $1.3 million settlement. I represented the hospital where she lived for a year. The woman's attorney informs me that they will not pay her bills because she is severely disabled. Never mind that she is currently receiving free medical care from the government. When I point out that we have a lien, the plaintiff's attorney tells me she will report me to the bar for unethical conduct. I firmly refused. So I file suit, and I have to do it in a small town in Texas. After I file suit, I go down because the judge has scheduled a hearing to figure out what is going on. He opens the hearing by asking me, "Which of the big cities are you from?" At the hearing, I explain that the reason she has a settlement is because she has medical expenses, and my client, the hospital, is the reason she has expenses, and we deserve to be paid at least part of that settlement. The judge proceeds to tell me that he will set it for trial. When the court reporter gets up, the judge looks at me and says, "I don't know why you're doing this. Medical bills are all made up anyway. They aren't worth the money it took to fly you down here." He gets up and leaves, and the plaintiff's attorney looks at me and tells me that if we go to trial, she is definitely going to report me to the bar for violating attorney/client privilege by looking at my client's own records. Now, attorneys, how would you proceed? Story 8. A client was born male and officially changed genders in another state, including her birth certificate, many years ago. She married an old friend who had become a widower with several children and then lived as his wife for more than a decade. Many years later, her husband was becoming senile and had not made a will. The couple now lived in a state that did not recognize same-sex marriages. However, reciprocity could be an issue. The client was the sole wage earner and providing care in her husband's declining health. Anyhow, her husband's children did not approve of their father's marriage to his old buddy and threatened to expose the marriage, i.e., the true gender of their stepmother, to overturn any sort of benefit or passing of assets to the wife on their father's death, or to challenge any sort of new will instrument. I was contacted to figure it out. No happy ending on my part, or at least unknown. I began work on the case and got a call from the firm owner/managing partner about 2 or 3 weeks later. "Jabberwocky, what file did you have?" Administrative coworker open. "She told me you gave her billing for client name." "Yes, client name. You gave me authorization to take a retainer and proceed on the case." "Well, you need to fix it. We can't have clients like that." "Like what?" "Fix it." Fortunately, I have a good friend at Lambda Legal, and was able to pass the client off into good hands. I argued for a while with my boss, before officially passing the case off, because it really, truly would have been a big case for the jurisdiction. And, thankfully, the Supreme Court has made these cases much easier, despite the opinions of managing partners or gray-haired, busybody administrative assistants. Story 9. It was my 3rd month of practice. I was in family law at the time, representing a mom in a petition for a restraining order against her boyfriend/father of the child. At issue in the broader case was child visitation, custody, support, etc., but today's hearing was just on the restraining order. We had pretty good facts, mostly based on testimony of the parties. My client was way more reputable as a witness, so I was feeling confident. 10 minutes before the hearing, my client shows up. I give her a last-minute prep on what to expect, and then she says, "I'm glad I'm going through with this. I can't deal with it anymore, and he's just getting worse." To top it off, he left me a drunken, ranting voicemail on Saturday. "You have your phone with you?" "Yes." We play the voicemail, and it's a full 2 minutes of ex-boyfriend screaming stuff like, "I should have really hurt you when we were together. You were always such a difficult woman. I hope you burn in a fire." I didn't have time to ask her why she hadn't told me about the voicemail before the bailiff called our case. We sit, the judge asks if either side has additional evidence, and I ask for permission to play the voicemail. The ex-boyfriend, who didn't have an attorney, didn't object, so I played the whole 2-minute rant in open court. The judge goes, "We're going to take a brief recess before I issue my ruling. If the parties want to meet and confer in the hall, they are welcome to." Boyfriend knew he was in trouble. We settled the whole case then and there. My client got her wish list in terms of custody, supervised visitation, child support, plus the restraining order. Story 10. It was day 2 of a child custody modification trial. The opposition and her attorney were completely unreasonable. Their allegations were so weak that I told my guy, forget it, let's go for custody ourselves. I'm cross-examining Mom about her proposed custody plan for Dad in some detail, and I ask her, would you accept this for yourself? She snaps back, absolutely not. I ask, why not? Because I'm a mother. To his credit, my guy kept a straight face the entire trial and never once got upset. Her petition was denied outright. Ours was accepted by the court. If the mom or her lawyer hadn't been such a challenge to deal with, my guy probably would have agreed to some small reductions in his custody just to keep the peace. Instead, the judge gave us nearly everything we asked for. Story 11. I represented a man in a slip-and-fall case in a national chain that grills chicken. The restaurant is not supposed to clean the grills until after they close because it is a huge, sloppy mess that involves using a garden hose after applying chemicals to remove all of the grease. The close-down process can take up to 2 to 3 hours that involve packing up the food for the next day, scrubbing the grills, mopping, etc. Even though the corporation knew this, they refused to pay more than 1 hour worth of wages after closing time. Thus, the shift managers and cooks decided that they would start the closing process 2 hours before closing, while there were still customers in the restaurant. This is really dangerous, as employees delivering food can track the greasy water into the lobby where the customers were. On one fateful day, 2 hours before closing, one of the cooks was cleaning the grills and using the hose to wash them down. This slurry is so slick that the cook has to wear a plastic smock and slip-resistant shoes for the process. While he was waiting for the chemicals to remove the grease, which takes about 15 minutes, the cook goes into the lobby, tracking this stuff into a hallway to wipe down some tables. My client walks out of the restroom and slips in the greasy water. He hits his head so hard that it causes a subdural hematoma, which requires surgery to relieve the swelling and blood from the brain. Go figure, the video system wasn't working that day. In any case, right after that the cook was fired, and the corporation claimed that they could not locate him during litigation. I did some research and found a relative of the cook, which eventually led to me finding him. He admitted that he was cleaning the grill, but denied that he was the one that tracked the greasy water into the lobby, as did all of the other employees. The corporation during the entire 3-week trial testified that cleaning before closing was against their policy, and it never happens. Thus, it had to be anything else that caused my client to fall. I was talking to the cook before trial because we were going to call him as a witness. He was pissed that they fired him. I asked, "Do you think they are still cleaning before closing because they are denying that they do?" He told me absolutely. On the first day of trial, I sent my investigator to the restaurant at the time my client was injured, which was 2 hours before closing, to record video on his cell phone, whether they were cleaning or not. Guess what? They had the hose out and everything. I couldn't believe that they would continue to do this at the restaurant, at issue in the case. I told my investigator to go back up there when there is a different shift manager and cook to see if they are doing the same thing. They were. At the end of the trial, the defense put on their general manager for the region. He swore up and down that this never happens. He was their last witness. We get up and say, "Judge, we need a sidebar." In the judge's chambers, we revealed the videos to the other side. The attorney for the corporation was freaking out. The judge let it in for rebuttal. The last thing the jury saw before going into deliberations was 5 minutes of video, with audio of the hose, as they were cleaning the grills 2 hours before closing. We completely wiped out their entire defense in a 3-week trial with that video. Needless to say, we prevailed. I should add, using sub rosa video against a defendant like this is very rare. They usually stop doing what they are not supposed to be doing during the trial. I guess the restaurant didn't get the memo. Story 12. Probably not exactly what you're looking for, but once had a sovereign citizen, if you don't know what those are, consider yourself lucky, in for not paying his child support, and was beyond difficult to work with in any capacity. I'm talking whoever he spoke to from my office, he would demand their phone number, current address, and social security number, because he thought he was entitled to it, since we're government employees. He also was just not a fun guy to talk to, and was just straight up rude to everyone. So these types of things rarely go to trial. and usually people don't even serve any jail time as long as they work with us. But not this guy. He was uncooperative the whole pre-trial process and refused to show up to anything unless there was a threat of warrant. Gets to the day of trial and he starts giving the judge crap over every little thing, demanding her SS hash, address, and phone hash, and claiming some weird straw man argument. Not the actual fallacy, but something to do with a legal identity. Your guess is as good as mine. He cited unrelated contract and business laws. Again, this is child support. But what finally did it was he called the judge an extremely rude person and was promptly found guilty and sentenced to the max time, 180 days. I literally did nothing but read his payment history, cited how much he was behind, and sat back to watch this guy argue himself into serving 6 months. It was pretty satisfying seeing him escorted out of the courtroom in handcuffs. Story 13. I prosecuted a guy for domestic violence a while back. He seriously harmed his girlfriend. The pictures were horrifying. She told the responding officers what happened and said he did it all the time. She kept going back to him because they had a kid together. Come the trial date, the victim and the defendant are back together once again. She got on the stand and told the judge that her wounds were from falling down the stairs and that the defendant had nothing to do with it. Defendant looked so smug. I didn't question her story too much because really, her life was difficult enough without me putting her through hell in court for lying. I called the victim's mother on the stand. Turns out she had been at the apartment when everything went down. She told the truth. The defendant took out his anger on the victim every chance he could get. Of course, the victim hadn't fallen down the stairs. Defendant got convicted. First time my office had successfully convicted a defendant for domestic violence with a recanting victim. It felt great. She probably went back to him, but maybe the classes he had to take helped him manage his anger better. I certainly hope so. Story 14. Lawyer here. Residential landlords can be terrible people. I'm a corporate lawyer whose only L/T experience is in commercial leases, but a friend of a friend was being told by her residential landlord, post-termination of her lease, that she and her 2 female roommates were not getting their security deposit back and they owed him additional amounts for repairs. This jerk was actually making improvements to that apartment and trying to do it on their dime. So I took some time to write a letter free of charge because I was so angry, wherein I demanded the entire security deposit plus a $500 in attorney's fees for having to write the letter. In reality, I thought I'd just get their security deposit and feel good about doing just that. But this guy definitely knew he messed up from the very beginning because he immediately paid every penny of the attorney's fees I demanded. He was such a terrible person that he saw 3 young female tenants as an opportunity to swindle them for their security deposit. And while I'm glad he paid up immediately and without a fight, I think it definitely demonstrates his conscience at the time. Story 15. Not a lawyer. I was a volunteer family advocate. I worked with families who were falsely accused of child abuse. Part of that was going to court with them. I was contacted by a family whose children were in foster care because of parental-controlled substance use. The family claimed that they didn't use any substances, and that no one would believe them. They had a court-appointed attorney who did nothing but tell them to stop using substances. I honestly didn't believe them. I was pretty jaded. I told them to request their case file for me to review. I was surprised when they called me back and had the case file. I met with them and went through everything. I noticed claims of substance use, court findings of substance use, but no test results in their paperwork. I told them to ask for the results. Long story short, the caseworker wouldn't give them the actual results, and the lab wouldn't either. So I tested them for substances myself at a different lab. They tested clean. Color me shocked. There were 4 months to go until the next court date. Every time CPS tested them for substances, they went right after to the other lab and did a second test. All clean. I told them to tell the lawyer beforehand that if CPS claimed any positive results, to ask in court for the test results. He didn't want to. I was starting to get mad. So the day of court, I had a stack of clean substance test results in my bag. The lawyer wouldn't even look at them, and he was openly hostile to my presence and involvement. Court starts. I had been in this judge's courtroom before with other families. The CPS supervisor stands up and says that the parents have had 12 positive results in the past 6 months. The lawyer actually did ask her for the results. She said she didn't have them with her. I got the results out of my bag and handed them to the mom who was next to the lawyer. She tried to get him to take them, but he ignored her. I got so agitated that the judge said, "Mrs. Baez looks like she's about to have a stroke. What's going on?" I stood up and explained that we had clean substance tests taken immediately after the mandated ones that CPS claimed were positive. I briefly explained that the parents had tried getting copies of their results and had been refused. I said that the parents had consistently denied ever using substances and had clean tests to prove it. The judge ordered CPS to provide copies of all the test results at a hearing in a week. At that hearing, the case was closed and the children were released from foster care. Story 16. Actual lawyer here, and this one was especially sweet, was involved in an ownership/control dispute of a Venezuelan company. While we had no doubt who controlled the company, opposing counsel had created enough smoke to create just enough doubt for our federal judge to order us to file a declaratory action. After a few months, we received the equivalent of a declaratory order from the high courts in Venezuela, basically saying our client was in control of the company. We had the order translated and certified and drafted a motion explaining to the court how these orders from Venezuela work, and how they are in effect the highest law of the land, which meant the case should be over and our client was in control. Opposing counsel drafted an almost identical motion, but they had not received a copy of the newest order. In other words, opposing counsel agreed with our position that these orders from Venezuela would definitively prove who controlled the company but attached the older order. We prevailed in the declaratory action, and the judge referenced the fact both sides had the same argument in the final order. Some background: the original Venezuelan High Court order, first order, created the equivalent of a receivership in the company we were representing. The receivership hired us to pursue an unrelated claim here in the States, against an American company. The receivership was put in place by the shareholders and the Venezuelan government, as the owner of the Venezuelan company, douchebag, was embezzling money and running the company into the ground. There was another firm representing the company before we were hired, and they decided to ignore the first order and claimed to the federal court here in Miami that they were the only ones representing the company, and that we were the imposters. They argued that the first order was not valid, and douchebag was still in control of the company. There was a second order was the result of an appeal in Venezuela that was very ambiguous in its language and cast some doubt as to the control of the company. Douchebag and his attorneys submitted the first and second order as support to their motion. A third order was issued by a different Venezuelan appeals court, which put the issue to rest. We asked for and received a copy of it. They did not, either because they knew it was not supportive of their position or because they dropped the ball. We believed it to be the latter. Our motion cited similar case law and advanced the same positions, but were interpreting different orders. TLDR. We did our homework, they didn't. Bonus TLDR. Venezuelan courts are whack. Story 17. I knew the cops beat up my client and framed him. They described a knife in his possession that caused them to fear for their safety. Oddly, they never seized it. We won the criminal case and filed a civil rights case. I was reluctant to take on the civil case, given the difficulty of proving police misconduct, but while deposing one officer, he described the knife in detail. No more than 3 minutes later, he slipped up and claimed his partner told him my guy had a knife, but he never saw it himself. I told him, "That's not what you just said," and saw him panic. His lawyer panicked too and asked for a break. After the break, they settled the case for a substantial amount. It was one of my most satisfying wins, turning a tough civil rights battle into a quick resolution. Story 18. She had insisted from day one that they'd been in a relationship, but the detective denied it. She gave us very detailed information about his house. He was divorced. Bedroom, bathroom, and the detective's body, scars, birthmarks, etc. She also told us he had private photos of her on his phone. We hired a private investigator to pull all of the text messages from her phone, deleted or not. There were hundreds and hundreds of text messages between the two. Some made it very clear they were in a relationship and that they were in an intimate relationship. He'd also sent her selfies in private settings. The private photos of her were also still on his phone. When confronted with the evidence, he folded like a lawn chair and admitted to the relationship. He was fired and lost his pension. The case was dismissed. The client filed a lawsuit and walked away with a huge settlement. The oh no moment was when the detective saw the printed out text messages. His face turned white as a ghost. Story 19. Ah, the ghost. Okay, so in the first place, it's always nice to get a client from a business card you left at a diner. It means people pick those things up. However, When leaving business cards at diners in certain areas of town, I should expect some issues. This call came through on a dreary December day, as I was sipping coffee and watching the snow fall. The caller ID read that it was the local hospital, and as I picked up, I spoke to a rather frantic young man, who informed me he was being held against his will and he needed an attorney to help him. When I asked where he was, he simply said, "The 5th floor." While this may sound innocuous, every hospital has a 5th floor, where Napoleon roams the halls freely and the residents speak to their imaginary friends who may, or may not, have been an influencing factor in why they decided that clothing was a way for the government to track them, and therefore the only solution was to create poop pants to throw off the monitoring ability of the CIA. Long story short on this portion, within an hour of the call a friend had dropped off my fee, and I was en route to the 5th floor to meet with my new client. I assumed it would be an involuntary committal defense, and after speaking with my client I gauged that, while the man was most definitely in need of mental care, he was not a danger to himself or others, and was unlikely to be one. He had, in my opinion, been forced to agree to being committed by his probation officer, and frankly, I wasn't going to let that stand. I got the name of some contacts from his treatment plan who were willing to vouch that he had, until recently, been compliant with his medications, and contacted his social worker, who was able to confirm that, yes, since he had ceased taking the medication due to an inability to afford the medications, the county would assist him with it. A slam dunk. I would simply use my authority as a lawyer in the mental ward and get him released, then appear in the court to defend against the involuntary committal. Within 24 hours of being committed, my client was back at home. A hearing was set a couple weeks in the future, and I did daily checks to be certain he was compliant with his medication leading up to the hearing, until the one day I didn't. A call from the local police was my tip-off. An older officer, one I was familiar with, called to advise they had responded to a disturbance at my client's home. He apparently had been screaming in an empty room loud enough that the neighbors were concerned, and called the police. The police officer, a friendly sort, gauged the situation and decided my client wasn't a threat, but asked what the situation was. "The ghost," my client had responded. "The ghost won't get out, and it won't leave me alone." "Well," said the officer, "I can tell it to leave." So he did. He told the ghost to leave, and then, apparently for fun, told him that it was a, quote, civil matter if the ghost refused to leave, and therefore an attorney would need to be contacted. At which point my client dropped my name, which resulted in the cop giving me a heads up. So I call my client, point he was inconsolable at the concept of sharing his home with the ghost. Keep in mind, I've been to this guy's house. This is the first I've heard of a ghost, but there is a competency hearing on the horizon, and this will not play well in front of the judge. The cop said it's a civil matter. My client repeated about the 18th time after I told him I was not, in fact, a priest, but was a lawyer and didn't know how to perform an exorcism. "What do you want me to do?" I snapped a bit. "Evict it." There are moments in time when you should keep your mouth shut. This is one of them, because the immediate response was, "Can you? That'd be great." Well, so, long story short, I ended up driving out there with a mock-up notice to quit, addressed to any spirits in possession of the property located at 1313 Mockingbird Lane without any authority under color of law, advising them that their possession was unlawful in nature, and ordering them to quit and surrender the premises, or any portion thereof, within 15 days of the date of this notice. As I was obviously unable to obtain personal service via hand delivery, I had my client direct me to the portion of the premises the ghost occupied, an empty spare bedroom, and made service by posting the notice to the door of the room. I then announced that the ghost had been served a valid notice to quit and surrender possession, and advised it that failure to comply would result in the filing of an action for unlawful detainer. My client was satisfied with this, and I left. The next day I called my client to confirm he was taking his meds and to make sure he wasn't yelling at the ghost. He was happy to report that the ghost had been quiet since the service, and he was confident it would leave. I was confident he had taken his meds, so I was happy. The hearing came up, and the judge dismissed the involuntary committal after reviewing the evidence. My client is still in his home, and the ghost has never returned.